I rise to make an intervention, as it was not originally my intent to speak on the bill before this Honorable House. From the outset, I would want to state that there is no objection to always having all necessary level of consultation that is required to ensure that the decisions taken by this Honorable House fall within the comfortable acceptance of the general public. But consultation, or the argument of consultation, should never be used as a tool also for political grandstanding. Of course, there are many different forms of consultation, many different forms of making sure that every effort is made to make the right decision. But just because you could wave the word of consultation in the air, which was very lacking, I must add, over the last, before August of last year, for 7 years. It's not sufficient just to wave this argument of consultation and cloud it with quotes out of context from judgments without actually getting to anything substantial. In fact, we looked at, and I know there is still discussions, as I said, we have no aversion to ensuring that a bill is fully ventilated. But I want to before I make this point, I want to make sure the point is very clear about, just mute this computer, make the point very clear about not using consultation as a tool. And it is amazing to me what some people will do just for the purpose of relevance or trying to be relevant. One point I would want to make about that consultation issue is that the memo from number 7 said that there were 2 options provided. You could have appealed the decision of the Court of Appeal. Let's look through that for one moment. If you appeal the Court of Appeal decision and it went to the Privy Council, and the Privy Council, let's say, agreed with the NIA's and everybody else's position that there ought to be no additional law or anything such that the NIA can sue, there will be no consultation. You understand? If you went to the Privy Council, we wouldn't have this. The public wouldn't become any wiser because the status quo would have then continued. So this idea that is being purported, that this particular thing, which has been established for 40 years, is in dire need of further consultation, I need to see more of what you're referring to. Bringing me to my next point, that in this House, there is a tool that allows for this Parliament to decide that if a bill has no general objections, whether in the Parliament or in the public, that it can be read for a 3rd time. Although that was not necessarily going to be the case here, because the option existed that we could start the debate, allow for some further ventilation, and come back and finish the debate at another time. That still exists and was always on the table. But when you come to make that decision, you're going to ask yourself, what are the salient points that have been raised that will allow or substantiate the need to delay the decision? So for instance, if this bill was saying X, and the opposition is saying, well, it should not say X, it should do this or it should do that, making it controversial, then perhaps you need some revision to that. But the opposition offered no amendment, no suggestion, no difference of anything within the bill.
The members who oppose, not the opposition.
The members who oppose, sorry. The members who opposed on the opposition. So the opposition is opposing the opposition, right? Right now. Has that ever happened in this parliament? The opposition opposing the opposition. They have not provided. The member for number 7, we all know, and I guess when you're on different sides of the aisle, it allows for persons to see that a lot of the flowery speech in the past was also not predicated on substance, but predicated on a grandiose style to suggest that you know what you're talking about. But he stood and spoke and offered not one contrary position to what the bill is purporting to do.
45 minutes.
Nothing. So therefore, like when...
Kind of point of order. I offered...
Let me speak. I recognize the Honourable Member for St. Christopher 7.
Yes, Madam Speaker. I put forward the concerns, which is my right to do. And I look to the legislation, the judgment, to say that every point that was being put from the other side have already been adjudicated on. That is the court to determine that they will not go any further.
Is this a point of clarification or a point of order?
Point of clarity, point of order.
You have a right
Madam
to rise
Speaker.
on a point of order, not a point of
You rule on
clarification.
it, Madam Speaker.
I am ruling now. It is a point for clarification,
Okay.
not for order. You raised issues, you opened a particular door, and so responding members, as I usually allow, have the right to respond to what is being put on the floor. Proceed, Honourable Member.
Thank you, Madam Speaker. So I want to make the point absolutely clear. The member for number 7 also referenced a bill that was passed in 3 readings for a church.
Yeah.
Now, the reason why that was able to be passed in 3 settings is because nobody in this house could offer an alternative perspective to that church getting what it needs to get.
But this is different.
So therefore, if it is, and I think there's also a further contradiction, because the member from number 5, in his...
Honourable Member for number 7, whenever you're speaking and someone interrupts you, I stop them. I give you the right to present. You presented for a number of minutes. Allow the Honourable Member on his feet to do the very same. I afford you protections, and so I must afford the others the same protection. Please stop interrupting the member for number 3. Thank you.
Thank you, Madam Speaker. Although I was not distracted. I kept going, unlike others. I was not easily distracted. Others were. But, Madam Speaker, the member for number 5, even in his opposition, said he has no opposition to the content of the bill.
He's comfortable with the timeline.
And so therefore, it is just pulling this argument of consultation out of the sky, it seems to be relevant, when they have not identified what it is needs consultation on. Because they could say, well, the way in which it has been structured, somebody might say it needs to be somewhere else. Also, what is being proffered here, or let me go further in saying that all that was mentioned by the member from number 5 and the member for number 7, I have a note here. There was no objection to any of the content. So in effect, there is no controversial aspect of the bill and what it is purporting to do. In fact, the court has said, in their opinion, that there is a particular lacuna because it is not specifically specified. So for instance, if we can think of something outrageous, like let's say the Constitution, I think, references that you can't take the life of somebody else, but it uses some language like you can't do something with life.
You could say the Constitution doesn't say you can have a government with 3 elected members, but they do it still.
You could say that, huh? I might come to that too. But the Constitution can say you need to preserve life or something. And we would think that we didn't have to write a law that says do not kill in order to preserve life. But somebody goes and says before the court that, well, the Constitution didn't tell me not to kill. And so the court says, and as usual, makes the point, walks out, doesn't participate in the discussion, is not interested in the debate, member for number 7, as is the case always, making the political point so that he could get the snippet, get it on his favorite social media platforms in order to get his particular message out. And so the Constitution might say you need to preserve life or something, and somebody brings a case and says, well, it did not say specifically not to kill. And so the Constitution, some judge somewhere says, well, you're right, it doesn't actually say that, etc. So we have to look at this and you have to look at that. You could take a decision, appeal there and go to the Privy Council, or you could go back, and if the Constitution allows you, say, look, you could do some amendments to things and so on. You can go back and write, do not kill. The discussion, the debates have already happened. The courts have already opined on this. And they have said, in their judgment, that something is missing. All this House is doing is coming to write that little something that the court said is missing, so that there is no doubt. No, I don't know the legal term for it. There's a fancy thing to say out of abundance of caution. What is it? Y'all remember it? Because it's what is it, Latin? I can't remember these Latin terms. But all we're doing here is saying that after all that has happened, all the things happening in the court, the back and forth between the legal people, the Attorney General's office, the Nevis Island Administration legal advisor, saying, you know what, let's just write it down so it's absolutely clear. And use the Constitution, the powers given to this Parliament by the Constitution to make that correction. And so, one very important thing is to say we are not amending the Constitution. I want to make that absolutely clear. The member for number 5 was mistaken in his comment, and if I hadn't made that objection, I am pretty sure the member from number 7 was going to get up and try to say the same thing. But we are not amending the Constitution. What we're doing is using the powers given to us in the Constitution to make a simple thing, not guesswork, but putting it in writing so that it is very clear. So it says on the bill, whereas under section 106(4) of the Constitution, it is provided that nothing in section 106(1) shall be construed as precluding the legislature from conferring other responsibilities on the administration. Now, I think it was the member from number 9 who had said, based on the fact that you were given full responsibilities, we did not think, or no one thought, that you have to specify that somebody can be sued and not sued. And so what this part of the Constitution allows us to do without having to amend the Constitution is to say, you know what, just so that we are clear, when you have a responsibility given to you in this regard, you can be sued and not sued. The Constitution gives us the ability to do that. And I also want to refer very quickly as well to a piece of the legislation, sorry, not legislation, the judgment that the member from number 7 was referring to. Let's see if I highlighted it. Yes. It is therefore clear, it says, that, comma, barring public law. So the judgment is saying, unless there is some law that establishes your ability to sue or not sue, then this is what our interpretation is. So we have then taken the option to use a law to make it absolutely clear. What would have been useful for the debate from the two members opposite who are opposing the opposition is to come and tell us if there was something wrong with what the bill is trying to do. And nobody is opposing that. Are they saying that when it goes to the bar, and for instance, are they saying when it goes to consultation, that people are going to come back and tell us that the court is wrong? That we shouldn't give the NIA the power to sue or be sued? Are we saying that there is a feeling that people in St. Kitts and Nevis are going to kick up a storm when we learn that somebody who makes a decision for $100 million can be sued or to sue? Is that the concern? Is something we're doing here going to cause people to think, boy, that's a controversial thing, boy? No. No. The NIA must be able to go into a contract for the airport, decide that they're going to spend $10 million, and if something goes wrong, that's not the responsibility of the NIA. That is what we are concerned of. Well, nobody offered those arguments. And so that is why the Constitution and our rules give us the tool to be responsible legislators to say, if something is uncontroversial, if something is clear as day and night, if something is a no-brainer, if something has been properly ventilated by different arms of our government over a period of time, then you don't have to waste any more time and just pass the change. That is what the tool allows us to do. In fact, we have that power to do so. I would not have minded if they came and said, look, there are elements in the society who think that the Nevis Island Administration should not be sued or that it cannot sue. But they have not offered that. What is before is uncontroversial. I can't use the fancy legal terms like the member from number 9 because, as he said some time ago, I'm only a lawyer by osmosis. I can't use those terms. But it is clear as day for us that nothing in this is controversial. I don't know what the term is when you have 40 years of doing something and then you realize because of some intervention that there is a word missing somewhere and you go and correct that word. You don't need another 40 years to just do it and get it over with. And so I want to say that we are not opposed at all to engaging in further consultation, and perhaps we could even have a discussion about that. But it can't just be for the sake of saying consultation. It must be because you have identified, and we agree, that there is something that is missing, and perhaps we need to seek further clarity on this issue. And so I found especially presentation from the member from number 7 to be particularly disingenuous because it used references to the court proceedings out of context in some instances, purported to speak on behalf of the NIA in a presentation that at the end of the day left us none the wiser as to why we must delay or not delay. Because there were considerations as to whether or not, as always, is this bill a controversial bill? Will it get opposing views from anyone opposite to the moving side of this bill? Or even within a particular side? Because as we saw, I don't know if the opposition or the majority of the opposition thought they would get opposition for this bill. Because if they thought they would get opposition for this bill, perhaps they would say, well, let's put it off a little longer. But we could not have thought that to make a statement in law that the Nevis Island Administration can sue and can't sue would be up for controversy. Because that is, I think, a very basic principle of law. That if you are responsible for something, you are responsible not to do the things, but for your actions as well. And so that is why nobody thought that it had to be explicitly said. And all the legislation here is doing is making it explicit that, one, we're not amending the Constitution, but we are saying in order to adjust the Crown Proceedings Act that came into force before the Constitution, that we need to make some basic changes to bring everything in line. And I think the Honorable AG made a very, very valid point that the Crown Proceedings Act is older than the Constitution. And it is quite possible that in framing the Constitution, there were some things that were missed. And it happens all the time in the development of law. You know, I always joke with the lawyers and so on, you know, in my field, engineering, very precise. The numbers haven't changed for 100 years. 2 + 2 has always been 4 for a long time. But in law, a law is written today, and tomorrow there's something found that it might be contradicting some other law that was passed 100 years ago, and so you have to come back and just make the adjustment. But the final point is not in contention today. And if there were arguments made that said that the final point of whether the NIA can sue or be sued was in contention, then we could accept the arguments. The other thing too to note is that even the way in which we have done it, in terms of using a new bill called the Nevis Island Administration Civil Proceedings Bill 1, or amending the Crown Proceedings Bill Act, even those were not under contention in terms of how we did it. The only thing is that they want, for instance, just to make a point, that we should have broader consultation. But they didn't say why. When you have broader consultation, it has to be that something is amiss. You believe that if you go this way, that's not going to be accepted by part of the community or the society, or you're going to be breaching the Constitution. So I want to make it clear as I wrap up that, one, we are not amending the Constitution. I think that was an unfortunate statement by the member from number 5, Because yes, as we seek for broader constitutional reform, the entire country, communities, all stakeholders will be involved in that process. So we're not seeking to amend the Constitution. What we are seeking to do is to use that Constitution. And I believe in the judgment as well, Honorable AG. The learned judges, or the learned court, said that they did not believe, it seems, the federal parliament was of the mind to let Nevis Island Administration be sued or to sue. The federal parliament.
As of 1956.
As of 1956. So now the federal parliament has come to clarify its position. Not to change the Constitution, but to clarify its position that yes, in fact, since it was not clear, as the Constitution has given the Nevis Island Administration these particular powers, the federal parliament, in agreement with the Nevis Island Administration, states that we all intended and have practiced for the 40 years gone for the Nevis Island Administration to sue and to be sued. So there is no requirement of the judgment even to have constitutional reform on that issue. The issue is how can we use law to close that particular lacuna in the Crown Proceedings Act. And so we are here today to use the Constitution that allows us to say, you know what? In fact, the Constitution allows us to say we'll give Nevis additional responsibilities. But we're not even trying to do that here. We're just trying to make it absolutely clear to everyone that if you do something against the Nevis Island Administration, that they can sue you. Because they have responsibilities for what they have responsibilities for. And if the Nevis Island Administration does something to you, you can sue them. That's all we're trying to do here. And if it is that there were objections to that their constituents expressed to them, it would have been worthwhile to bring those objections here as to why we should not continue the debate. Because if they said, look, my constituents are saying that there is a better way that we can do this, then we listen. If they say that instead of doing a bill called the Nevis Island Administration Civil Proceedings Bill, instead of this it could have been something else, we would listen. But they didn't offer any of that. They didn't offer any objection. They didn't offer any content improvement. They didn't offer anything other than to say, we shouldn't do this simple thing in a sitting of Parliament after it has been exhausted by all arms of our government. First, of course, the court, and we're now doing it, and then the executive, because the executive consulted to determine what they will do based on what the court has said, and now we're coming to the Parliament to make a simple adjustment where none of them who have gone before have identified an alternative position that is available. And so I really want to, I was saying that one, we're not here to amend the Constitution in any form or fashion. And two, we're just here to make it clear, since it wasn't before, although everybody, all the legal, what was interesting from this, that member from number 9 said, is that the legal fraternity who was involved in this case, the legal fraternity said they understood this to mean that the NIA can be sued and that the NIA can sue. So even in that fraternity, There's no objection. And so the Parliament was just being efficient in doing all that the work that it has to do. Come here and say, you know what, let's make this simple change. But the reality is, if members had found credible things that needed further discussion, because they didn't offer any, if we pause now to consult, we don't even know what we're going to consult on, because they haven't offered an alternative view. And so I want to support the bill before this Honorable House, the Nevis Island Administration Civil Proceedings Bill. It is uncontroversial. There's no contention here. If it were, I would certainly want to support that we make sure we take it out and go to, Gingerland Primary School, wherever we have to go. But I don't think that that is needed here. I don't think it is needed. There are a lot of other critical matters that require further ventilation. Let us not use consultation as just a political tool to do your grandstanding. Stand, get your pictures, your video, your snippets, your shots. Honorable member, that is Pat. Honorable Speaker, please, I think that is Pat. That is, we have to understand. Yes, I think so. I think it is important to observe that, and for the public, because I want to stress this, Madam Speaker, if you would allow me. The public does not get to see a lot of what is happening in here. Right now, I'm looking at a monitor, and all that the public can see is me speaking, right? And I need to lose some weight, boy. Or that screen spreading me out, man. Yeah, we got, you know me, I don't like that. The ratio on that screen is wrong. That is stretched, and it is wrong. Madam Speaker, that speaker's at that screen monitor, the proportion is wrong. It's stretching me out. But all I can see on that is myself speaking and our interpreter, and I want to congratulate and commend them for the work that they're doing, such that those who have impairments in terms of hearing can be able to follow our proceedings. That's all they can see. And that is all that is going to be recorded. So what the member for number 7 was doing was using that in order to get a capture, to make a political point, and then leave the Parliament not to further himself in the discussion, in my opinion, Madam Speaker, in my opinion. And so I want to support the bill before this Honourable House, Nevis Island Administration Civil Proceedings Bill. I think that it is uncontroversial. We have discussed whether or not we need to spread it out any further, and this consensus is that there is nothing else to debate on this. And so I know that the AG will now come and clear up any other misgivings or misunderstandings that some may have had. With those couple of words, may it please you, Madam Speaker.